Hello, everybody. Good morning.
Good morning.
Can you hear me?
Yes.
Okay. A little bit. Just by way of background, I used to work for the Department of Real Estate. I was a Deputy Commissioner 1, 2, and 3, and a legal counsel with the department. I worked for them for over 9.5 years. More importantly, I've been representing real estate licensees and applicants before the Department of Real Estate now for about 21, 22 years. I've been doing this for over 30 years. Today, what I'd like to talk about are some new things that are happening at the DRE, some legal interpretations, some things you probably are aware of, some things you may not be aware of. First of all, does anybody know that the Department of Real Estate is going to be dissolved?
No.
They're going to be replaced as a bureau. Their new, we know them as DRE, they'll now be known as BOR. Bureau of Real Estate. The governor has proposed dissolving them. You may be wondering why the governor is doing that. That is correct. The DRE has routinely loaned money to the general fund, and if they don't exist, they don't have, the general fund doesn't have to pay it back. Will it have an effect on you? Initially, probably not. My understanding, all they're doing is changing the name on the door. Eventually, will it? Possibly. The DRE is one of the few agencies that actually has its own legal staff. And they're being transferred from the BTH, Business and Transportation, over to Consumer Affairs. Currently, there is no real estate commissioner. The last real estate commissioner was a civil servant who had this appointment temporarily. She retired last month. There very well may not be another commissioner. We'll see about that. That's set to, well, the proposal hasn't been finalized. It's going to go through the Little Hoover commissions of the legislature. But come July, it's possible the DRE in its present form will no longer exist. The next thing, which is sort of interesting to me, I've been doing this for about 30 years, and this is a new interpretation of 101.37 of the Business and Professions Code. It deals with paying, brokers paying salespeople their commissions. Haven't seen this interpretation before. Personally, I think it's sort of dumb, but that's besides the point. Basically, if you're a salesperson, and let's say you're working for a broker and you decide to leave, and then you earn your commission with the old broker, but you're with a new broker now, the DRE, it's in the spring bulletin, you should take a look at this, it's actually sort of interesting, has now decreed that if you are a salesperson who's gone on to a new broker, the old broker either has to pay the commission check made payable to the new broker, or hand the commission check to your new broker made payable to you. You can no longer get your check directly. It's a ludicrous interpretation because in the same article it goes on to state, but if you don't have a broker, then your old broker can pay you directly. If that doesn't make any sense to you, it makes no sense to me whatsoever. Something you should be aware of. All right. Those of you who are brokers and do escrows, there's going to be new reporting requirements effective July 1st, 2012. Personally, really what this is about is so you can be targeted for an audit. But if you don't comply with the reporting requirements, that's if you do 5 or more escrows or do $1 million or more in a calendar year with you will have to do these reporting requirements. There's some very draconian penalties if you don't do the reporting. So please be aware of that, and please, it's not effective until this coming July, but it's something you're going to need to deal with. Some things you may be aware of. Also, if you're a broker doing escrows, make sure in your designation, if you use the word escrow, a non-independent broker escrow. You need to have that in your paperwork. You can no longer say XYZ escrow company as a DB of your license. So be aware of the fact that you need to add that. Next, all of you, or not all of you, some of you may deal with short sale negotiators. The DRE has interpreted, and I sort of agree with this, a short sale negotiator needs to be licensed. You cannot use an unlicensed short sale negotiator. If you're a broker or a salesperson involved with this, this is a violation and you will get in trouble. So make sure that whatever short sale negotiator you're using, if they're within your company, they have to be a salesperson or a broker associate. If they're an outside company, they have to be licensed by the DRE and would be a broker or a salesperson working for that broker. DRE has a new program to resolve disputes. They have advocates now. I'm waiting, I've dealt with a couple of this stuff. Normally, the interesting part about the advocates program deals with areas that the DRE previously thought they didn't have jurisdiction. So, or to resolve possible violations. We'll see what happens with it. It's a new program. Just be aware of the fact that it does exist. New laws, effective January 1st, 2012. For most of you, this is not going to have any impact whatsoever. If you have another licensed discipline, let's say you have a contractor's license or some other license, you have 30 days from any other licensed discipline to inform the DRE or it's a violation. If there is an indictment, most of you will not have anything to do with this, but if there's an indictment filed against you for a felony charge, you're supposed to inform the DRE within 30 days. And previously, you had no duty to inform the Department of Real Estate if you're convicted of a misdemeanor, whether that's a minor traffic offense or something along those lines, or a felony. The law has been changed. If you have a misdemeanor or a felony, you have 30 days to inform the DRE of that misdemeanor or felony. This is a similar code section that the Department of Insurance has. That's where the DRE got it from, to be honest with you, for insurance licensees. The Department of Insurance tends to be very lenient with people who don't report. We'll wait to see what the DRE does with this. All right. If there is a disciplinary action filed against your license, the DRE has amended the code. Previously, if there was a trust fund handling violation and a final determination, the DRE was able to charge for an audit and a follow-up audit. Now it's been amended that any case that the DRE files formal charges against you for, and there is a determination, they're entitled to the cost of investigation and the cost of prosecution up to the hearing. What that means to you is if the DRE files an action based upon a technical violation, they can still try and get money out of you, even if you settle the case, which is what normally happens if I'm representing you. All right. Another thing, probably most of you, this is not going to affect you. Restricted licensees, if you have a restricted salesperson or broker's license, the DRE now can charge for the cost of monitoring. They haven't determined what that is. However, they can do it. If you have a restricted, again, I'm just going to go through everything. A lot of this is not going to deal with you. If you have a restricted license and you want a petition to have the restriction removed, or you've had, well, nobody here would have a license revoked, but the DRE now charges effective May 1st, 2012, $800 to do a petition to reinstate a license. All right. New thing the DRE did, they now issue citations with a fine. They can fine you up to $2,500. The initial thought when this was proposed by CAR was to avoid accusations. The DRE manipulated, this is my interpretation, this is just my opinion of what it's done. Previously, sometimes the DRE would do an audit, find a minor violation, they wouldn't do anything with it, and they would just simply send you a letter saying you need to comply with this, and they would go away, or they'd come back in 6 months to see if you complied with it. Now they can fine you, and they basically up to $2,500. If you don't pay the fine, they will not renew your license. You can challenge the fine, and you have 30 days from the receipt of the fine to request a hearing. If you're hiring a lawyer, or well, if you're doing it yourself, maybe it'll pay. It depends on what the violation is. Sometimes you may want to just pay the money and get it done with. My personal opinion is you're now paying for something you used to get free. Moving on, and then we'll go to questions. All right. All right, the DRE has a new law effective January 1st, 2012, which is sort of bizarre, more than anything else. It's B&P Code Section 1088, which basically means that under certain circumstances, they can talk about an ongoing investigation, even if there's no final determination. They can identify the people that are involved. If they file an accusation or desist from restraint order. What is bizarre about it is an accusation or desist from restraint order is a public record, so they can talk about it in any case. But it's sort of to give them some leeway that if they feel that somebody's a real bad character, that they can respond to inquiries from the newspaper. The only problem I have with it is that the DRE sometimes, or a lot of times, it may not be correct in their interpretations of law or the violations, and it's prejudging somebody. I have a little problem with that, but that's something to be aware of. One thing that's happening at the DRE, and this is only going to affect those people who might have had previous discipline on their license, they're converting their website, and what they're doing is this. Previously, if there had been a disciplinary action against somebody, all it would say would be the discipline, release, and then it would give the case number. Anybody wanting to find out further information about the type of discipline involved would have to contact the legal section, would have to do a decent amount of legwork, I should say, to get information about the prior discipline. What they're doing now is they're putting the accusations and the final disposition, the actual documents on the website, and anybody who clicks on your license can just click on the document and download the document. With regards to some of it, it's pretty bad. I do a lot of audit cases with the Department of Real Estate. I've been doing this a long time. In fact, I've probably been doing this longer than a lot of the people at the DRE. I find many mistakes in interpretations. I find many mistakes in violations that don't exist. And because of that, normally what happens is I end up settling the cases for a lesser discipline. Normally what we do is we settle for a few minor violations. The problem is there's going to be an accusation, and I've seen accusations out there that were just totally off the wall, that really there were not a violation, and then there was some minor, let's say there was a major allegation which was totally unfounded, and then a minor violation. So we settled on the minor violation. But now there's going to be a public record there that anybody can click on and get to, even though you did not admit to those charges. That's disturbing. That's something you should be aware of. Again, only affects those people who have discipline. Those of you who have the endorsement to do lending, you probably know what you had to go through to do that. I'll just leave that alone. If there are questions, I'll ask them. And with that,